Hello, my name is Chris Cassi. I am a special education teacher at Washington High School in Kansas City, Kansas. I just finished my 8th year, going into my 9th year coming up. Um, Definitely the hardest job I've ever had. I've worked retail management for many, many years, and special education is definitely much more difficult. However, I have a desire to make sure that all students are able to learn, and I am looking forward to eventually moving into the administrative abilities of special education. So that's where I hope the future takes me. For this assignment, I was given the Covington versus Knox County school system case, and so I will describe what this case was about. As with almost all cases, it is they're a little bit confusing, as this case starts out as one particular thing and completely is turned into something else by the end of it. So the plaintiff in this case was Burma Covington, and she is actually representing her son, Jason Covington. Jason has a lot of emotional disorders and a lot of behavioral disorders that I'll speak about in just a moment. The defendant in the case was Knox County School System, or the school district, along with the Knox County Board of Education. So this included the superintendent, the principals, and basically just everybody involved in the school system. So Jason was enrolled in the Knox County School System Special Education School from 1990 to 1996 when he finally graduated. The original complaint, though, for this case was filed in the school district in 1994. Covington filed the complaint later on in federal court in 1998, which we'll get to, and then finally the conclusion of the case does not appear until March of 2000. So what brought about the case was essentially that Burma Covington alleges that the Knoxville Adaptive Education Center, where her son Jason went, violated her son's rights essentially by locking him in a timeout room. It was described as basically like a 4 foot by 6 foot room. It had a window about 5 feet high on the wall, and did not have any ventilation, heat, air conditioning, or anything. It's basically a closet with a small window. She brought the matter, his mother brought the matter of abuse to the attention of the school system because he would be locked in there for hours on end. Sometimes he'd be forced to relieve himself in that room. And on one occasion that they have addressed is that he was forced to undress in the room before being put in the room. The Knox County school system responded to Covington's complaint by finding that they didn't do anything wrong. Essentially, they said that the timeout room was indicated in the IEP and that his mother did not follow the due process procedures under the IDEA Act. Essentially, they were saying that this should not have gone to court, that she could not file it in court, that she needed to deal with the school district herself, and the school district said that they're not doing anything wrong and offered no other remedies. So, from 1994 to 1998, the case was just constantly delayed over and over again, and in part this was due on Covington. I'm not really sure why, but that's what they described. Following the almost 4 years of delay, Covington then filed the case in federal court. So she kind of sidestepped all the other courts, went straight to federal court. The Knox County School District said you can't go to federal court. You didn't exhaust all of your administrative remedies provided in the IDEA. They also argued that she would not be able to seek monetary remedies under the IDEA Act, and so she filed it in federal court without the mention of the IDEA. So both are kind of the school district is basically saying you can't take this to federal court. This needs to stay within our school district, or at least in our district court. So the exhaustion of administrative remedies, essentially saying that Ms. Covington needed to follow particular procedures before she could file in court. However, she argues that she does not need to exhaust her administrative remedies under the idea, essentially that Jason has already graduated from school and that the only remedy to this situation would be monetary because the school district can't provide anything else for Jason at this point. So at the conclusion of the case, the federal court sided with the plaintiff and sent the case back to the district court. Essentially, the federal court was saying, look, the district court was wrong. They misapplied the law. It's true that, usually you have to exhaust your administrative remedies under IDEA, but in this case, that would be just futile. That would be pointless. No reason for that. So the impact on special education is that not all cases involving students with disabilities require the exhaustion of administrative remedies. So that's where this court case kind of took a turn. It started out as an abuse claim, and it ended up being more of a procedural claim and how the process should work. So you don't always have to follow the due process clause of the IDEA. In this case, the remedies for the situation would have to be monetary. They can't go back and say that we'll take him out of the timeout room or anything like that because Jason had already graduated. So that is the main impact on special education. All of this information can be found at rights.law.com under the Covington versus Knox County School System. This was just a summary of what happened and the impact that it gave. Thank you for your time, and I appreciate you listening.